Get ready. 5 seconds. 2 seconds. Start. The trial court appraised the evidence adduced by the prosecution and came to the conclusion that the deposition of PW1 and PW2 were completely reliable. The trial court rejected the contention urged on behalf of the accused persons that the delay in the logging of the FIR was not satisfactorily explained or that the prosecution ought to suffer on account of its failure to explain the injuries sustained by the accused persons. The trial court also rejected the contention that there was no motive for the commission of the offense or that there was any contradiction between the medical and ocular evidence laid in the case. The trial court, on the reasoning, sentenced all the 10 accused persons arraigned before it to undergo imprisonment for life under Section 302 of the IPC and a fine of rupees 5,000 each. In default of payment of fine, they were directed to urged further rigorous imprisonment for a period of 1 year each. They were also sentenced to under rigorous imprisonment for a period of 1 year and a fine of rupees 1,000 with a default sentence of 3 months each under Section 325 of the IPC. For the offences punishable under Section 323 and 148 of the IPC, the accused were sentenced to pay a fine of rupees 1,000 each. No default sentence in regard to those offences was, however, awarded aggrieved by the conviction and sentence awarded to them. The appellants filed criminal appeal number 631 of 2000 before the High Court of Punjab and Haryana, Chandigarh, which was disposed of along with criminal revision number 345 of 2001 filed by Vedpal, the first informant, by a common judgment and order impugned in these appeals. On behalf of the appellants, it was argued that the courts below had fallen in error in convicting the appellants by placing an implicit reliance upon the depositions of PW1 Vedpal and PW2 Prakash, and in the process ignoring the defense version about the genesis of the incident. It was contended that the incident had occurred on account of an attempted act of sodomy by the deceased upon Jaipal, to which the appellant had objected, resulting in lathi blows being inflicted by the two sides rivals to each other. The argument needs notice only to be rejected. Full stop and over.